benches. That's a good thing to hear. You know, these two terms, constitutional morality and transformative constitutionalism, you know, these two have been bandied about in the recent past, substantially in the courts and in the court corridors, and also amongst public intellectuals. Now, what is this thing that we call as constitutional morality? Is it a kind of brooding omnipresence or unarticulated major premise of the Constitution? Now, if it means, as Grote contemplated, and as Ambedkar also expostulated in the Constituent Assembly, of a respect to the constitutional norms, rule of law, and not seeking revolution, etc., then we will have no problem. But today, at least in the last 3-4 years, there has been a reference to this expression constitutional morality in a number of Supreme Court judgments. And it is being talked about as if the legislative action can be held to be unconstitutional on the basis that it is in violation of constitutional morality. We have heard of laws or executive action being struck down on the basis that it is violative of the legislative competence or of the fundamental rights, that it is an unreasonable restraint, arbitrary and unreasonable restraint of the fundamental right. But this is a new trend which is at least being talked about. Now, I enter into two caveats on this. One, in a democracy governed by rule of law, not by rule of men, not by the whims of men, we exercise the franchise and elect a legislature, the parliament or the legislative assembly. They have the power to make the laws. The laws will have to conform to the Constitution. All powers of all authorities, including the legislature, executive, and judiciary, are derived from the Constitution. Everybody is answerable to the Constitution, to the people. The time when an argument was made that you will have to test laws not only on the basis of the written letter of the Constitution, which sets out certain limitations in regard to the competence or fundamental rights. It was rejected times without number, starting from 1951. In fact, in A.K. Gopalan, Mr. Nambiar started with due process. They said no, due process was considered not accepted. In Keshav Madhavan Menon in 1951, the spirit, the so-called spirit of the Constitution was advanced, and that was not accepted. We have seen so many such instances where every attempt was rejected. For the first time, when the constitutional amendment was challenged as being violative of the basic structure, the court said, yes, we may have to necessarily import an implied limitation, because the amending power otherwise had not been subjected to this kind of a restraint, and you can't amend the Constitution out of shape, out of what it was originally contemplated to be. Therefore, the theory of implied limitations, which Mr. Nambiar had first propounded in Golaknath, was not accepted, was further argued in Keshavananda Bharati, and that was accepted. And this is based on a very well written article on the Irish Constitution by a German scholar, and that was accepted. Now, the repeated attempt to have this spirit of Constitution or the soul of Constitution to be one of the bases, a kind of a brooding omnipresence to test the laws made by the legislature, has never been accepted. And I'll give you a number of instances. I mean, in case you need to, note down, I can give you several instances where this was sought to be done. And this was never accepted. One I said was Keshan Madhamanan, that is 1951. Then Ambedkar, one of the founding fathers of the Constitution, he argued the invalidity of the Zamindari abolition laws in UP, Bihar, and a number of other states in 1951. And in state of Bihar versus Kameshwar Singh, this argument is referred to. This argument is referred to by Chief Justice Patanjali Shastri, as also by Justice Mahajan. And in fact, the argument is expressly rejected. This is what Chief Justice Mahajan says: the spirit of the Constitution cannot prevail as against its letter. The elusive spirit is no guide in the matter. And he quotes Dr. Ambedkar's argument relying on Justice Nelson in People versus Morris, and he rejects it. Now, therefore, you have situation where as early as in 1951, this was rejected. In the bearer bonds case, if you recall, in 1981, there was the persons who were holding cash could convert it to bearer bonds. And this was challenged on the basis that this is violative of the spirit of the Constitution again. It offends the morality. More express word used is Mr. Garg's argument. He was a petitioner also. Mr. R.K. Garg was the petitioner, public interest petitioner, he said. And the judgment said, it was then contended that the act is unconstitutional as it offends against morality by according to dishonest behavior who have evaded payment of tax, immunities and exemptions which are denied to honest taxpayers. Now, this argument was rejected. You can't import this morality or constitutional morality unless it finds a place in the Constitution otherwise as a restriction. When the privy purses were abolished, it was a moral commitment and it got incorporated in the Constitution. There were about 600 and odd Rajas whose territory merged with India. And they were all assured certain rights, including privy purses. This was abolished. This was challenged. Again, the argument was made. This was in 1994. It was submitted that amendment is an ugly epitome of immorality perpetrated by the Indian Parliament. Then the Attorney General's argument is noted. And then the conclusion is, the above passages remind us of the distinction between law and morality and the line of demarcation which separates morals from legislation. The sum and substance of it is that a moral obligation cannot be converted into a legal obligation. In the light of the above principle, Attorney General is right in saying that the courts are seldom concerned with the morality, which is the concern of the lawmakers. Therefore, that was the view taken. This is as late as in 1994. Then we come to 2004, where in the breweries, Devon's modern breweries, there was again a challenge on the ground of public morality. then the submission is rejected on the basis that when statute permits a trade, morality takes a backseat as legislature as contradistinguished from judiciary. Now, in spite of so many of these decisions, we now have, starting from Justice Shah's first invoking constitutional morality when he struck down 377 in Delhi High Court. That came to Supreme Court, and the Supreme Court did not uphold that view. But of course, it came up for reconsideration. We have a whole host of cases, starting from the Delhi laws, the dispute between the Union of India and the Delhi administration in regard to the legislative competence and authority, etc., where this was invoked. We have the case relating to Navtej Singh Johar, that's in regard to the rights of the minority community in respect of, not in the sense of religious minority, in regard to sexual minority. Therefore, the two important cases which have arisen there, one is in regard to whether 377, to the extent that it makes it prosecutable, is invalid. And secondly, also in regard to the discrimination of the homosexuals. So both these cases came up for consideration. Then also the case of Joseph Shine on adultery. These are some of the cases where this has come up. And recently, two other cases. One is the Sabrimala case and the defection cases in Karnataka and Maharashtra, where also this principle of constitutional morality has been invoked. Now, interestingly, if you see all the cases which are referred to this and the judgments, none of these has actually used only the concept of constitutional morality for striking down a legislative act. They have used that as a kind of a brooding omnipresence, but struck down the law on the ground of Article 14. The broad Article 14 as envisaged in Rayappa and Menaka Gandhi by Chief Justice Bhagwati, where he said arbitrariness is a facet of Article 14. And today, manifest arbitrariness is now also available as a ground for striking down. And you would find in all these cases, although there is a reference to constitutional morality, the actual provision in the Constitution which has been invoked for the purpose of striking down is Article 14, manifest arbitrariness. Therefore, one is tempted to ask the question, is this a kind of a halo which is being created over the expression constitutional morality, or is it available as an independent ground, even if Article 14 is not violated, to strike down a law? And in my view, it is not available, it should not be available. We have an unelected set of judges. I think the legislature, in its wisdom, enacts laws. If it violates the written law, the Constitution, one can strike it down. But to invoke the spirit of the Constitution, the soul of the Constitution, or this brooding omnipresence of constitutional morality to strike down a law, in my view, would perhaps not be appropriate. This is broadly what I wanted to say. I had the necessary material, whatever you want to ask, I think it would be more useful if you raise the questions and we can have a discussion.
So you want the questions to be asked at the end of the session or right now, sir?
You can, I think you can start now. I think I don't want to take up more of your time on a lecture. I think it would be better if you have questions. If you ask me, I'll be able to interact.
Okay, so I'll just wait. Who are all ready with the questions, and I can ask them to ask us. Just a minute, sir. One Mr. Mayappan Advocate is waiting in the line, sir. Mr. Mayappan?
Yeah. Sir, can you hear me?
Yeah.
Yeah.
You can ask him.
Yes. Honorable Justices, respected Speaker, and learned friends. Sir, you had brought up the 2004 breweries case and the concept of public morality. I believe that this case is even pertinent even today, because you said, sir, that when there is a law that allows the sale, then public morality should take the back seat. But the law itself is to control the sale, not to promote it. When the government takes up the sale of any psychotropic substances, for another example, in certain places like in the Varanasi, I believe, I understand, I don't know whether it continues, the government sells the marijuana and the bhang. That is aimed at controlling it, not promoting it, to making it available to a select, maybe for medicinal purposes, because even that, the oils are, having medicinal value. And in that sense, the liquor is sold by the government to control it. But we see the contrary happening here, sir. And I believe, when we are talking about whether we should have judicial activism, I would say that it is not good to have judicial over-activism. It is not good enough to have judicial over-activism. We need something, the judicial godfatherism, sir, under the circumstances. we need to enter, we need to step in, we need to step up the game, sir. And I'm really emotional. I know, considering the circumstances, I would like to stop there. Thank you, sir. We've lost fathers, we've lost husbands, we've lost people, more than Corona has taken, I believe we've lost them to liquor. And these people are least bothered. They are promoting it. And we need to take something, sir. Thank you.
See, I think the essential concept of the social contract and the need for a government is for the purpose of ensuring an orderly, regulated kind of governance where rule of law prevails, dharma prevails, and there is peace. And you can pursue your right to for pursuit of happiness. But there is a contrary viewpoint, at least to a limited extent. Is the social contract for having a nanny government? That is, the government being in the nature of a nanny to regulate whether you will eat this, you will eat something else. You will drink this, you will drink something else. You will not smoke, or various other things. See, these are questions on which, unless the action of the individual is going to affect others in the sense of somebody else's right, then to what extent the government can regulate and should regulate is an issue which should be left to the wisdom of the legislature. I don't think it is a matter for the courts, therefore, to intervene. We have an elected government, a democracy in which you elect a government. If today the party realizes, which is going to polls and seeking vote, that look, liquor is an issue. Now, what happened? Tamil Nadu, the old Madras presidency, was one of the first states as far back as in 1937 when Rajaji was the chief minister, which brought in prohibition. It was never a success. Now, you have seen in the USA when prohibition was introduced, it was never a success. And what did Vinoba Bhave say? Vinoba Bhave, a very true Gandhian, who walked all around the country. In regard to prohibition, he said, you can never succeed in enforcing prohibition. You have to persuade, you have to educate people. That is the task. You can regulate, but you can't say absolutely no liquor. You have seen what happened after 40 days when the liquor shop is open, there is a huge crowd. There are some people who want it. Now, I think the state should not take this moralistic attitude. It can. The legislature can. The legislature in its wisdom can pass a law totally prohibiting. Whether it is desirable,
Absolutely.
it is not for the court to judge. But court cannot say, state ought to have done, therefore we will now direct imposition. That I think is inappropriate. We are
Absolutely,
now
sir.
discussing the power of the court.
Yes, sir. I totally understand, sir. I'll close with this observation, drawing the attention of this seminar to Krishnamurthy versus Collector, the judgment by Honorable Justice Chandru. There, because any reasonable man, if he sees that this particular shop is going to affect the neighborhood or the school or the temple, whatever, that should be taken into consideration, because the act says so many feet, and these people have literally gone around it. They are, taking us, the entrance is here, you have to walk around the place and then reach it. In my place, sir, if you jump across the compound wall from the school, school, if you jump across, you will get to the liquor store. And that is near the temple, near the railway station, and they are still running it. Because the inspector who comes, he goes around the law. He goes around this particular act.
No, it is not the absence of the law. Most of the states have made laws in regard to where a liquor shop should be located. It should not be near a school, it should not be near a temple, near a church, near a mosque, places of worship. Various other restrictions are there. Therefore, if the executive has not complied with the law, then that is a matter which the court can look into and say that, look, it is within the prohibited distance and you ought not to have allowed it. That can be done. But
thank you, sir. Yes, sir. Yes, indeed. And a little bit of the interpretation by the courts also, could go a long way, sir. That is also there. Thank you, sir. Thank you so much.
Enforcement, therefore, is certainly within the hands of the executive, and if they don't, the judiciary can always direct them to enforce it.
Indeed, sir. Thank you, sir. I'll leave the seminar to the others.
Mr. Vaidyanathan. Thank you, Mr. Vaidyanathan. Incidentally, sir, I just see a flash news on the TV that the government of Tamil Nadu has announced that TASMAC shop will not be opened in Chennai. In Chennai, because of spread of COVID, like a forest fire. So as you said, it is left to the legislative wisdom to decide either to do or not to do.
Correct. Correct.
Let me go to next person, sir. One Mr. Prakash Sannasi. Prakash Sannasi, sir.
Yes, sir. Yeah, thanks.
You can talk to the chief guest.
Sir, I just want to your opinion on the strike down of 370 for Kashmir, and even though the northeastern state, some of the state has continued special provisions, I want your opinion on that. That's it. What is your take on the constitutional standpoint?
No. See, the court has taken a view, therefore, my view doesn't matter. But the point that I was making was, it has been struck down on the violation of Article 14. It is not on the basis of constitutional morality. That's the point that I was making. Therefore, the court has taken a view, and I think, I personally feel that it is a right decision. And till such time as it is unsettled by a larger bench, it will continue.
Thank you, sir. Sir, I have a personal question, if you don't mind.
Yeah.
Sir, the morality as a word may not have a consistent meaning. What was moral yesterday may not be moral today, or in the vice versa, what was immoral may be moral tomorrow. For example, homosexuality, I may openly say that it has been committed, what is called, found to be a sin by all the religious practices. Even I think Bible declares it as a sin. And even masturbation is said to be a sin under the Bible, and our own scriptures, holy scriptures, calls a lot of things as immoral, but now they have become an order of day of late. So how to, what is called, to update or to have a drawing line as to what could be the moral value of a particular act of a particular period. How can we define morality as a consistent value or norm?
See, I think in India, it was never considered immoral. Till the Victorian, let's say 200, 300 years ago, the English approach came into India and this provision got introduced. If you go to Khajuraho, or if you go to some of the other old temples, you will find including in Karnataka, you will find depiction of homosexuality. Therefore, this is Victorian prudery which has come into India after, in the medieval times in Europe, this kind of on account of the assertion of the church in Europe, this kind of an approach came in. In Hindu India, I don't think it was something which was frowned upon. You will find that. You will find a lot of textual material also, even amongst old literature. This is, I think, a natural instinct. So, and Hindu philosophy accepts diversity so easily. It has never, therefore, frowned upon it. I think what was earlier there, say 500 years ago, that has only been restored today by accepting it as a reality by the.
Yes, sir. I get you. So I'll go to next person who has got a question to ask you. Miss Rajini, you can ask the question to Mr. Vaidyanathan.
Sir, good morning, sir. This is with regard to Sabarimala judgment. The public morality is that women are impure. They don't have a right to enter into the temple. But constitutional morality was upheld that women are equal, that there should not be any discrimination on the ground of gender. Therefore, the age-old tradition of prohibiting women from entering the temple was abolished and in the Sabarimala judgment. Therefore, it is a global phenomenon that women are equal and women have a right to enter, right to worship on equal footing. Therefore, why the Honorable Supreme Court is again and again referring it to that discriminating women on the ground of the worship gender and preventing them from right to worship is against global standards of equality and things like that. Therefore, I am a bit confused why Supreme Court is again and again entertaining review petitions and referring it to larger bench, and it looks that the Honorable Supreme Court is yielding to the political pressure or yielding to the pressure of or adhering to the public morality at the cost of constitutional morality. Therefore, what would you like to say, sir, on this thing?
See, you have raised a very important and sensitive question. See, there are two competing rights. One is the right to equality of women. The other is the right of persons to follow certain religious precepts, practices, beliefs. There are two competing rights. Wherever the Constitution desired that the religious rights should yield to the right to equality, they have said so. Now, you don't find a reference in Article 15 to a place of worship providing equal treatment to women. It talks of places like parks, recreation, various schools, various other things. In fact, even in regard to education, you will find Article 29 doesn't mention that there should be no discrimination on account of sex, because at the time the Constitution was enacted, it was well known that there were schools and colleges which were only for boys and girls. Therefore, this segregation was recognized, accepted. That is why you don't find that in Article 29 also. Now, how is this right? Please consider the right to worship. You have diverse beliefs. These are recognized. The faith and belief, preamble recognizes it, Article 25, Article 26 recognizes it. Now, if I have a belief that the divinity in the idol in Sabarimala will be affected by a person, by a woman in this age group, in the period of menstruation. Now, that is my faith and belief. Now, will his right not be affected by conceding equality to the women and saying that? And how is the right of woman to worship? What is the right that is being asserted? Right of access to a place of worship. Equal right of a woman for access to a place of worship. That is what is being asserted. There are thousands of temples of Ayyappa which are available where a woman can go. It is only in this one single instance where she is not being allowed. Now, is that not therefore a balancing of the rights? You know, there is a very instructive case from South Africa, which I shall be referring to in the course of my arguments in the Sabarimala matter. The case was in an educational institution, there was a uniform rule which said that nobody should have an earring or sport a nose ring. So a person of Indian origin, a South Indian origin, she said, I have faith in my religion. There is a practice in our religion that we have this ear piercing and we put this. Now, why are you prohibiting this? No, therefore, that's a very, very interesting case. If you see that, you said, yes, you are talking about equality so that everybody should have the same uniform and nobody should wear any ornament, nobody should have piercing, ear piercings. But this constitution also guarantees a right to religious faith, religious practices. So how, by that, is your right to education affected? That is a question. Therefore, both competing rights can be allowed to stand. Now, the woman's right of access to a place of worship, every other place of worship, every other place where Lord Ayyappa's idol is there is fully protected. Therefore, to that extent, there is a balancing of the competing interests. And I would therefore think that the Supreme Court is not wrong in entertaining the review petition and taking up this larger issue for consideration. What they will ultimately hold is yet to be seen. But this is a submission which is going to be made.
Thank you, sir.
Let me now move to, thank you, Ajimam. You can mute yourself. Let me move to Mr. Gopinath Balakrishnan. Mr. Gopinath.
Yes, sir. Good morning, sir. Sir, I have two questions. First is the term constitutional morality is to be defined with review in Sabarimala judgment. My question is, will the term constitutional morality turn itself into a basket like the basic structure where things have been put into it has been an encompassing term, or will it stay as a term which cannot be properly defined? And my second question is, I don't know how much it is important in the present aspect, because in US, where in Supreme Court there are 9 judges, everybody's political orientation is well known, and before a case is put to them, people try to the realist to jurist following the realist school try to calculate the outcome of it. If constitutional morality becomes a separate chance to question a legislative piece, will the orientation of the judges also play an important role in deciding what is moral or not?
You're absolutely right. In fact, what Justice Vivian Bose said long ago in 1951 itself about the subjectivity in regard to these of the judges is a very vital thing. You know, when Anwar Ali Sarkar, this is what Justice Vivian Bose said. I can conceive of cases where there is utmost good faith and where the classification is scientific and rational, and yet we should offend this law. Let us take an imaginary, and then he goes on. And then he says how the subjectivity of the judges, however much the real ground of decision may be hidden behind the screen of words like reasonable, substantial, the fact would remain that judges are substituting their own judgment of what is right and proper and reasonable. It is inevitable for this kind of a thing happens, and then he quotes Dicey on that. Therefore, there is a lot of subjectivity. You know, when we talk of even in preventive detention law, subjective satisfaction, it has to be based on objective factors. Now, when you test a law for arbitrariness also, there are a number of objective factors which are taken into account, and then it is decided. But a term like constitutional morality is an animal which cannot be defined. Now, therefore, that is what happened. The 8 blind men going and trying to find out an elephant what it is. Therefore, each one has a different view. So that will be the kind of result if you leave it entirely to the judges to use constitutional morality to construct the law. And that is why, in my view, they have not so far done it. And I only hope that they don't do it even in future. It is one thing to say that you have manifest arbitrariness or the classification is wrong and therefore it is violative of Article 14, or it is disproportionate. Therefore, when you test reasonableness, proportionality is one of the considerations. Now, there may be some amount of subjective element, but it is fairly regulated, guided subjectivity. But in using an expression like constitutional morality, I don't think there is much guidance in regard to what it is. And therefore, that will be an unruly horse. That's my view.
Thank you, sir. Thank you for sharing your opinion.
Thank you, Gopinath. So you can mute yourself. I'll move to next person. Is Manjula Aran. Manjula, ma'am?
Yes, I'm here, sir.
Yeah, you can talk to him.
Okay, sir. Sir, I think it is right to understand the constitutional morality as the right spirit in which one has to realize the constitutional ideals. And whenever there is a controversy between the public morality and constitutional ideals, then you have to uphold the constitutional values, and that is how the constitutional morality is brought into force. So, sir, now, whenever there is a gap between the constitutional morality, so constitutional morality and the statutory deficiency, given the understanding that constitutional morality also encompasses the constitutional obligation, is it not obligatory on the part of the state to make every law incompatible with the constitutional morality? For example, we know pretty well that whenever the Hindu Succession Act and in adoption law and everywhere, there is a discrimination against women. It took 40 years to accept women also equal co-partner as that of men. So when there is such a difference, and if it is not remedied, what is the accountability and how it can be remedied even without taking into the litigation before it is being taken as a litigation?
Okay, two things. One is
Yes.
in regard to this Hindu Succession Act, etc. I think if it had been challenged, perhaps on the ground of discrimination, it could have been struck down earlier, and that has been the view. But on this public morality and constitutional morality, I think we have to make a distinction between majoritarian morality and public morality. See, when we say public morality, it is a morality of the not just the majoritarian, either in terms of religion or language or sex or any of these things. So we have to make the distinction. What the Constitution guarantees is that the majoritarian morality cannot dominate to suppress the minorities. To that extent, there is no difficulty. Therefore, if minorities have certain rights which are enshrined in the Constitution, that is part of the constitutional morality. That is something which is already written in the Constitution. It is not a brooding omnipresence. It is not an unarticulated major premise which, if one were to conceive of that. Therefore, these are express rights which are conferred by the Constitution. There are express limitations imposed on the exercise of legislative power or the executive power. You can't discriminate against the minority on the basis of religion, language,
sex or otherwise.
Therefore, those are things which can be asserted, which can be enforced, and the courts will enforce them. But what is not expressly written in the Constitution, if you try to divine it on the basis of so-called spiritual of the Constitution, and that is something which is not expressly provided for, but you have necessarily to imply it or infer it, then you are now invoking the principle of implied limitation, which was invoked for constitutional amendment. But for ordinary testing the validity of ordinary legislation, that has never been done, and I don't think that should be done.
Okay, sir. As you pointed out that public morality is fluid and it changes from time to time. But constitutional morality is static and its broader contours are already defined by the very same Constitution itself.
In fact, that is where the other expression comes, transformative constitutionalism. Now, there is the original theorists, both in American Supreme Court and some judges here also. Therefore, we have to look at the original meaning of the Constitution as it was understood at the time the Constitution was framed. That can't be. It will evolve over the course of time. Therefore, as you rightly say, the public morality changes, the constitutional morality also changes, it evolves. Now, in our Constitution, Ambedkar expressly said so in the Constituent Assembly. We don't want to have a rigid framework of the Constitution. Therefore, we have provided the amending power also in this manner, so that it will not be very difficult to amend as Constitution progresses if the approach changes. But the court also can possibly invoke this. But transformative constitutionalism cannot mean that it will depart from, or the court will start directing the legislature to enact laws in accordance with what they feel is the law, what they feel the law should be. That contrary to the separation of powers, and the judiciary will be stepping into a role which is not assigned to you.
Yes. Very informative, sir. Thank you so much. Thank you, sir.
Thank you, ma'am. You can mute yourself. Let me move to next person, Mr. Salahuddin. Salahuddin, sir?
Yes.
You can talk to the chief guest.
Sir, good morning, senior. Sir, this is Advocate Salahuddin from Coimbatore. And good morning to every participant who participate in innovative program. Sir, my question is, why Honorable Supreme Court takes long time, Your Honor, sir, deciding the matter pertaining to the succeeding MLA, which was struck down by Honorable High Court, even though the tenure is going to come to end as far as Tamil Nadu Assembly concerned. Senior advocate knows one Radhapuram area, one MLA who succeeded merely on 99 votes, and he got struck down by Honorable High Court of Chennai, Madras. Then subsequently, the same has been stayed by Honorable Supreme Court. Still, they are about to give verdict. Apart from that, the tenure of the MLA is also going to come within May or April next year. They are going to face. That's the first question. In addition to that, Honorable Chief Minister of then State Government, Mr. O. Pannirselvam, who defected, and 11 persons case also yet to the verdict yet to come. Why this type of so much delay, and what is the reason, Senior?
See, first of all, I must disclose that I have appeared in the 18 MLAs and 11 MLAs case for AIDMK party. In fact, I have appeared.
Thank you, Senior. Thank you, Senior.
Therefore, first, I must make a disclosure. Therefore, my view may be biased.
Thank you, Senator. And I don't know that. Sorry for that.
No, it could be biased. But you have raised a larger issue. This argument about whether the speaker should be vested with this power. That's a larger issue which was considered in Quixote of Rohan. And the Constitutional Bench, then presided over by Chief Justice Pankaj upheld that view. Although Justice Verma differed in that. Now, there is a debate on this. The speaker also gets elected on the party ticket, and thereafter, after he becomes a speaker, he gives up the membership of that party, but he may go back once he takes down the office. So to what extent he can be objective and unbiased? This is a larger issue which needs to be considered, but the Constitution, the Parliament, while exercising the Constitution amending power, while enacting the 10th schedule, considered that speaker should have the power. Now, this question of the defection and to what extent the members who are elected on a party ticket should be allowed to chain the parties and chain the horses, ayaram, gayaram things. This is a very, very important question in a democracy.
True, sir.
And it has arisen not only here, but in some of the other countries also. And it will gain greater prominence, but ultimately, it is a matter where we have in a democracy a system where people elect the legislators. Now, can the court direct that? No. Therefore, question is, will the court be trampling upon the powers of the speaker and of the legislature if the court were to direct that the matter should be disposed of in a particular time frame? That is the question which was raised and referred to a larger bench of 5 judges. But the same judge, Justice Nariman, felt that no, it was unnecessary. I had referred it, but now I feel, I had not looked at a particular judgment. I feel that it is not necessary to be referred. Therefore, that it will come up someday for hearing. And I don't want to express a view because I
accept your since I accept your fairness, sir, and I accept your clarification. Thank you very much. Thank you very much.
Thank you, Mr. Halaluddin. You can mute your mic. Let me move to Mr. Vijay Kumar.
Please, sir. Please.
Vijay, you can ask the question.
Sir, good morning. From your observation a while ago, I understand that you are not in favor of reading implied restriction into exercise of any powers under a specific article under Constitution. Am I right, sir?
No. What I am saying is our Constitution is a very detailed Constitution.
Right.
We have taken note of whatever happened in US or Europe or other situations, Australia, Canada, and wherever any restriction was required to be imposed on legislative power. The Constitution has said so. Having done that, are we now going to imply one more limitation which is not expressly articulated in the Constitution? That's the only question. We implied a limitation in regard to exercise of Constitution amending power, because that is a much larger power. You can't possibly leave it to the Parliament while exercising amending power to say that no, there will be no election, or there so and so will be the permanent Prime Minister, or so the judiciary will not have power, because that is the extent to which one can go. Therefore, the court said no, you can't amend the Constitution out of shape. There is an original framework. The basic structure is there. That basic structure cannot be amended. That is what they said. That is the implied limitation. That was needed to be read into Article 368. But in respect of exercise of legislative power, you have all of Part 3, which is a restriction, because the fundamental rights cannot be breached. Article 13 says so. Similarly, Article 245, 246 lays down what is the scope of legislative power in regard to Parliament and in regard to state legislature. There are similar certain other provisions in regard to, like, for example, professional tax. There is an express provision. All these restrictions are already set out in the Constitution. Are we now to imply one more restriction in regard to exercise of legislative power? That's a question. And I respectfully, my view is that this is not something which has to be implied.
Thank you, sir. Let me now move to Mr. Suresh Kumar. Mr. Suresh Kumar.
Sir, good morning,
Suresh.
sir.
Yeah.
Can you hear me? Hi, sir. Good morning, sir. In this social era, sir, actually the judges are also influenced by the media, because the media was deciding what we want to see or what they want to show us. So how is it possible, sir, upholding the constitutional morality by the judges themselves? Because they didn't distance between from the peer groups or the general public or the media. So how far they have to uphold the constitutional morality?
Sorry, I didn't follow the question. You said the media, I mean, can you repeat the question?
Yes, sir. Actually, today's era was the media formed era. So the judges, they didn't themselves or themselves distance from the media or social group, everything. So how is possible they are upholding the constitutional morality? Because yourself saying that the constitution itself is remodifying or reducing every time.
No, see, therefore, the idea is that the judges should exercise their power in an objective fashion without being influenced by the media reaction or the public reaction. They have to, therefore, as you, in a way, you are right that what is morality today is determined by the media or by the public. Now, that cannot possibly be allowed to influence the decision making by the judges. That therefore, you are really supporting the view that merely because a particular view is being propounded day in and day out by certain media, that cannot form the basis for adjudication by the court.
Thank you.
Thank you, sir. You can mute yourself. Next, Mr. Vasanta Kumar. Mr. Vasanta Kumar.
Sir, good morning, sir.
Morning.
Sir, I would like to ask one question is that access to justice is the constitutional morality except the Supreme Court. What do you think about establishment of National Court of Appeals, relieving the Supreme Court from its mundane work and the constitutional issues allowed to be decided by the Supreme Court?
I am wholeheartedly in agreement with that. I think today the Supreme Court is overburdened. There are 60,000 cases pending, and every month about 3,000, 4,000 court cases are being filed, most of which get dismissed, of course. I think the court should really become a constitutional court. You know, this idea was proposed at the time during the emergency by Justice Matthew, but unfortunately at that time the bar was not receptive to it because it was felt that it was an attempt by Mrs. Gandhi to control the courts in an exercise of the judicial power. But I think we need to have a relook at it, And Mr. Venugopal has been taking the same view. He has appeared on behalf of a petitioner in the Supreme Court and said that regional courts of appeal should be set up and then Supreme Court should confine itself only to matters of public interest, constitutional importance, and maybe in regard to interstate disputes, state-central disputes. These are the matters where it should really have jurisdiction.
So I am the petitioner. I am very much grateful to KKV sir. Sir, and very much grateful. He has guided me a lot, and I devote my praise to him, sir.
No, I completely agree with that view, and I think we can't possibly have 34 or 35 judges in the Supreme Court and all of them sitting in 2 and 3, and you have as many Supreme Courts as there are benches taking different views. I don't think that's a desirable thing. We should have Supreme Court in constitutional matters sitting en blanc of 9 judges or whatever it is.
Sir, and one more thing is that 145 class 3 says that it should be 5 judges to decide a question of national importance. But recently Supreme Court has said that Lily Thomas and that Information Technology Act, 2 judges of Supreme Court decide, including 2G also. What's your opinion on that, sir?
See, in the earlier days, when there was less pressure of work, you would find most of these cases have been decided by 5 judges in the Supreme Court. That was a time when the registrar will call up the lawyer to find out whether he has any case to fight. That was the kind of situation. But today, when you have 60,000 cases, and on Mondays and Fridays you have some 800, 900 cases being listed in different courts, there is hardly any time, and therefore it is very difficult to have 5 judge benches or 9 judge benches sitting. It is only exceptionally that they sit.
KK sir used to tell me that his father MK Nambiar would receive a call from the registrar saying that we are free, you please come and argue some cases where you are doing admit. That was the situation then, sir.
Yeah, times change.
Yes. Thank you very much, sir.
Thank you, Mr. Vasanta Kumar. You can mute yourself.
Yes, yes.
You can now mute to Ms. Jessie Jeevapriya. Jessie, ma'am.
Good afternoon, sir.
Hello.
Good afternoon, sir. Sir, I have a doubt, sir. Sir,
Yeah.
for giving equal right to women in property, this 2005 amendment was made. So in that amendment, so that by birth, a woman becomes Upashana.
You're not very audible. Sorry.
Jesse, you can use the mic closer to your mouth.
Okay.
Get your
Hello.
mic closer
Sir,
to
can you
your
hear me, sir?
Yeah.
Now you.
So by the amendment 2005, a woman became co-partner by birth.
Yeah.
But now the judgment says, sir, for filing any suit, the father must be alive.
Mm-hmm.
But that take away that is a bar, because whenever she born by birth, she acquires the right of co-partner.
Correct.
So now after this 2005, whether the father is alive is a correct one, sir.
No, what perhaps the judgment has said is that since it is an amendment which has been brought in
2000.
Yes, therefore, if the father was alive as on 2005, then you will have the right. If the father has passed away earlier, then the succession has opened. If the father had passed away earlier, the succession had opened, the rights have vested in certain person, then to that extent, it can't be reopened. That's perhaps the view that the court has taken.
But sir, in pending cases, I had a case where the son filed a partition against the father. Pending suit, the amendment came. Now, but before the amendment, 2004, father died.
Therefore, the succession had opened before the amendment. And if the amendment is not retrospective, then it can't. That's the problem.
But whether it is retrospective or not, yet to be decided, no, sir. It is before the.
If it is purely explanatory, clarificatory, then perhaps it can be retrospective. But if a new right is being conferred, which will affect the vested rights, then unless the statute is made expressly retrospective, then the court won't construe it as a retrospective.
Thank you, sir. Thank you. Thank you.
Thank you, Jesse. You can mute yourself. Let me move to Mr. Satish. CSK Satish.
Yes, sir.
Yeah, you can talk to the chief guest.
Sir, good morning, sir.
Morning.
Sir, we having a written constitution. In my feeble knowledge, I have gone through the constitution where I can able to find the word morality, at least at 2 places. That is one at Article 19, or 3 places, 19, 25 and 26.
Yes.
Sir, am I right in my understanding to think that the term morality was coined by the forefathers of our constitution on the basis of their understanding of the word morality, and with a very specific understanding that any future law or action of the legislature should be tested by the honorable courts only on the basis of the term morality as enshrined under the Article 19, 25 and 26, to mean to say restricted to religion and matter of personal belief? Or can we understand that it gives an unfettered right to the honorable courts to use the term constitutional morality beyond these Article 95, 25 and 26, which may lead to a situation as let Honorable Prime Minister Pandit Nehru felt that it will create a third chamber of parliament. How can we understand this, sir?
Yeah. No, I think you have raised a very valid point. See, the Constitution, as you rightly said, has used the expression morality only in the article. Now, you have to interpret the expression morality in the context in which they have used it. 25, 26, when it talks of morality, it is in the context of the religious rights. Now, that was never in the context of constitutional morality. Today, the expression that constitutional morality is sought to be imported into Article 25, 26, even in the Sabarimala case. That is the difficulty. I think you have rightly pinpointed the meaning that will have to be given to the use of the expression morality is not as constitutional morality in the sense it is being understood, and to now constitute the court as a third chamber, as you put it. I agree with that perception.
Thank you, sir.
Thank you, Mr. Satish. You can mute yourself. I will move to Mr. Sivasubramanian. Mr. Sivasubramanian, sir.
I have one request. I have
yes.
At 12:15 I have given time for some other conference.
Only two more persons. Only two more persons. Okay. Mr. Sivasubramanian, sir.
Yes, good afternoon, sir.
Yeah,
sir. Yes, as a blessing in disguise, this COVID lockdown has brought lectures from great legends like you, sir. First of all, my heartfelt thanks to the organizers and for you, sir. My view is that, sir, recently the most of our Indian citizens, especially the legal fraternity, felt a hitch that the top judicial officials, especially constitutional post-holding judicial officials, should be banned to join in a political party in a short period of their retirement. They should maintain that judicial morality, isn't it, sir?
Joining a party or taking a new office?
Something like that.
Okay, yeah.
I think this is a matter for each one's conscience unless the legislature steps in and enacts it. It is not something which can be enforced by the courts of law.
Yes, sir.
So,
thank you,
final
sir.
question is from Mr. Kumar. Mr. Kumar, you can ask the chief guest.
Yeah.
Thank you, Bhagavan. Thank you. Good morning, sir.
Yeah. Morning.
Sir, I have only one question, sir. Sir, our preamble says that our state is a socialist republic. But on the other hand, the successive governments, irrespective of the political party, now the government is focusing on and promoting private investments in a large sum, more particularly after the world LPG. Flooding of money from the private corporates and the MNCs are flowing like anything. which is against the concept of socialist ideals. The word socialism is maybe of a broader sense, and it may be interpreted in different ways. But so far as my little knowledge is concerned, socialism never doesn't promote private accumulation of property. But now the state is focusing on investment in private sector. That is true in the core sectors of the state. It suit and amenable to the word constitutional morality, sir.
Okay, now I'll tell you, it's very interesting that the original constitution didn't have the expression socialist. This was introduced by the amendment, 42nd amendment during emergency. The concept of distributive justice was in fact one of the matters which was discussed in the Constituent Assembly, and Ambedkar didn't believe that this must be incorporated in the Constitution itself. And that is why the word socialist doesn't occur. You have a large number of amendments which came about thereafter, where the concept of distributive justice or special preferences, etc., being given came up. Now, there is always a debate about the economic theories, to what extent the government or the public sector should play a role in an economy. And there have been differing points of view. But in view of what has happened today in COVID, I think we have a situation where what FDR Roosevelt did after the 1929-30 in US has been brought about. And you have seen actually, we need to spend considerable amount of money for the purpose of improving our health care, public health, social health facilities. And that is the realization which has dawned upon most of the government. And you will perhaps see a greater amount of money being set apart for education and health after this emergency that has befallen the entire world.
Thank you, sir.
Thank you, sir. Sir, there is one more person waiting. Do you have time or shall I close, sir?
Yeah, please, please.
It's only last question of it.
Yes.
Mr. Ilangovan. Mr. Ilangovan.
Sir, good afternoon, sir. Sir, in addition to the CSK Satish question, sir, it is not the duty of the court, just government decision by looking into the basic structure of the Constitution, which I can say which includes into the spirit and soul of the Constitution, sir, rather than by popular morals. And in addition to that, I find Rama Janmabhoomi judgment is more or less the decision based on the popular moral of the people. Sir, what would be being the advocate, we have two phases. So one is to pro, one is for against. And what would be the ground to review the Rama Janmabhoomi case, sir, if it is you are going to done it? You are going to do it, sir.
See, this is question which I had addressed earlier also in regard to what extent public morality can assert itself and for the purpose of now. This is a matter left to the wisdom of the legislature. The courts cannot step in and then direct legislation to be made. The interpretation of any law can be made to accord with the morality as conceived, as you see in the Constitution, as written in the. But possibly no direction can be issued, no manifest can be issued for legislation.
With regard to the ground to review the Rama Janmabhoomi case, sir, if at all you are going to argue for review of the Rama Janmabhoomi.
Any chance of reviewing Ayodhya Verdictly once?
No, I don't think it's likely to happen.
Yes, sir. What would be your review?
Review petitions have been
withdrawn, sir. Withdrawn. What would be the review? Being the advocate, we should have two phases now, sir. For and against.
Yeah, there can be views, but right to file a review petition is also available. That has been exercised and the review petitions have been rejected. Now, whether the court will interfere in a larger bench for the purpose of setting aside, that's a matter. We don't see the possibility.
Yes, sir. Yes. Thank you, sir.
Thank you. Thank you very much. Thanks to all the participants. It has been a lively discussion, and I must thank all the organizers for this opportunity. Thank you.
Thank you, sir. We should thank you wholeheartedly for the very deep-rooted thoughts and very considerable time spent in interaction. Thanks a lot, sir. We can never forget this session. Thank you very much. Thanks a lot.
Thank you.
Yeah.